All right. Sorry I'm a little late, y'all. I was having some issues. I'm still trying to learn how to work this stuff, y'all. But anyway, um, let's go ahead on with the live. So until I get some questions, excuse me, I'm gonna start teaching some stuff. Well, just reading some stuff. Where are we at? This ain't it. Okay, okay. If y'all have any questions, just post your questions below, and then we can just go from there. But I'm about to start reading. I'm trying to find this document. Who was it? There was somebody in the chat last night. There was somebody in the chat last night, and he had some questions. I think he said he was from Ohio, but he was traveling through Missouri, and he must have got some type of traffic citation or something, or the police stopped him or something like that. And I think his person caught a so-called charge or something like that. And he was, according to him, he was challenging. I think he was challenging the jurisdiction, if I'm not mistaken. So if he was challenging the jurisdiction, um, it would be the minimum context. That's what he needs to attack. I'm not sure who that was. So if you're watching this video and that was you, please comment below because I want to talk about that for right now. So I'm gonna have to go to the, well, you know what? He said he's Ohio and he was in Missouri. So it would be better to post Missouri case law. So that's what I'm gonna do. How everybody doing tonight? I think I might be a little too loud, so let me get back from the microphone. Hit that like button for me if y'all don't mind. Please hit that like button for me. Let's get on here. He was in Missouri, so we got to go down some more right here. Here we go. So Missouri, and we got to go to, we're going to type in due process minimum context because all of this stuff is the same. It's just universal all across the board. So the, the is in my opinion, it would be very easy to get that case dismissed. Although you can't, you don't have any control over the so-called judge and the prosecutor and all that stuff. But what I'm saying is to get your facts on the record. So we're gonna say due process, and this is for Missouri, y'all. Due process, minimum context. Context. And you know what? I'm gonna throw in territorial jurisdiction too. Now, what I'm doing is I'm typing all of this information that I'm talking about. I'm typing all of this into Casetext. Casetext is a search engine, so it works just like Google. That it's a search engine. So you have to know the keywords that you're looking for. The key, so you can pull up the cases that you're looking for. Should I say? That's what you're looking for. All right, let's see. In the first step, we determine whether the defendant's conduct satisfies Missouri's long arm statute. Then it says if it does, then we next determine whether the defendant has sufficient minimum context with Missouri such that asserting personal jurisdiction over the defendant's comports with due process. This is all that's what this is, man. The trial court exercises general jurisdiction over a foreign corporation must satisfy due. Let me see. That's not it. Due process requires a foreign corporation to have minimum contacts with the foreign state for the foreign court to exercise. Okay, this is perfect. This is a perfect case right here. It says this is from 2019, and it says the due process clause requires that a foreign corporation. So we're gonna replace the word corporation, um, and we're gonna use the term citizen or whatever. So it says the due process clause requires that a foreign citizen have minimum contacts with the foreign state for the foreign court to exercise personal jurisdiction over the defendant. They have to prove it, y'all. They can't just say they got it. He who asserts, the burden is on he who asserts. So if that's what they're claiming, then they got to prove it. Can't just say it. You got to prove it. For Missouri to exercise personal jurisdiction. Here's another one right here from 1986. For Missouri courts to exercise personal jurisdiction over a non-resident defendant, the defendant's acts must fall within one of the categories of the long arm statute. So what they did was it sounds like to me what they did was they codified exceptions to where they can properly exercise in personam jurisdiction over your person, your legal person. That's what it sounds like to me. Let me see. The long arm statute and must constitute sufficient contacts with Missouri so that the exercise of jurisdiction by our courts satisfies due process requirements. I don't know who that was who posted that, but I really wish that he was in this chat room right now, so I can get this information out to them. And I think you can only post. What can you post? You can only do up to 200 characters on Facebook. They're not gonna let you type any more than that. Can y'all hear me? How's the volume? And how's the quality of the video? Can y'all hear me? Let me know how it is. The petition also demonstrates the standard for determining whether to exercise jurisdiction. I don't know what that was. Anyway, the standard for determining whether an exercise of jurisdiction over the interests of persons is consistent with the due process clause in the minimum context standard elucidated in international shoe. So that's where they get the case from. That's what they're talking about. But notice they are throwing this word person around everywhere. Just person. They use this word everywhere. And they get so many people with this because they think that they're talking about you and they're not talking about you when they use the term person. That's not what they're talking about. It's not what they're talking about. That minimum context applies. That's pretty much everywhere, y'all. That whole minimum context thing. That's everywhere. So if you're traveling, if you're traveling from, let's say, Georgia to Mississippi, and you get stopped maybe in Alabama, or you get stopped in Mississippi, whatever, you are foreign to them. You're foreign. So they have to when they cite you for a so-called traffic citation or whatever it is, they have to prove jurisdiction. It'll be personal jurisdiction. And when they say minimum contacts, let's say, do you have a bank account with that state? Do any of your kids go to school in that state? Do you work in that state? Do you have a mailing address in that state? Those are minimum contacts. And I would have to study that some more, but I know all of those are minimum contacts with the foreign state. So this is some sort of It seems like it's some sort of business or something. I could be wrong, but that's what it seems like to me. How's everybody doing on this Saturday? This Saturday, the exercise of specific personal jurisdiction must also comport with the traditional due process notions of fair play and substantial justice. Well, yeah, that's a no-brainer. Let's see. Texas courts may assert in personam jurisdiction over a non-resident if one, the Texas long arm statute. Notice they keep this long arm statute. Long arm statute. It's the same thing that they had in Missouri. It's the same thing, y'all. Long arm statute authorizes the exercise of jurisdiction, and two, the exercise of jurisdiction is consistent with federal and state constitutional due process guarantees. Same thing, y'all. Same thing. It's the same thing. All right. Anyway, sorry about the I don't have a call in number tonight, y'all. I scheduled the wrong date for the show, so I can't get a call in number until tomorrow. So I do apologize about that. But I'm here to answer questions, and we can talk if y'all need to. Minimum contact analysis is required only if one of the traditional territorial bases of personal jurisdiction, such a presence within the jurisdiction at the time of service, is absent. So let me see. This is a minimum contact. This is from 2011. Says a minimum contacts analysis is required only if one of the traditional territorial bases of personal jurisdiction. Well, I know all legislation is territorial. I do know that. But I don't see how the people come within um, this so-called territorial jurisdiction because you can't see it. It's just like it's a fiction or something. We do not find minimum context for the state of Missouri sufficient to satisfy the due process requirements necessary for personal jurisdiction. Respondent in his brief asserts that jurisdiction can be presumed upon the fact that a Missouri resident heck sustained personal injury. Yeah, I would agree with that. What's good, JR? What's good? What's good? JR, if you're watching, um, how good is, I mean, like on a scale of 1 to 10, how good is the quality of the video? I need to know how good the quality of it is. Scale of 1 to 10. One second, I'll be right back. Oh boy. Sorry about that, y'all. Sorry. Okay. Okay, I appreciate that, JR. So the quality of the video is good. Sorry about that, y'all. I had to step away. Um, Today I actually went to the store to the store. Where did I go? I went to Best Buy today to get the video. I mean, not to get the video, but to get the laptop today. I just got tired of it, and I said, you know what? I already got the money, so let me just go and get it. So I went to go and get it. You've been doing your homework, JR. You've been studying, man. Let me check whose comment that was. I'm not sure if that was your comment or somebody else's. Oh, he texted me. Okay. Said quality is very good. Appreciate it, man. All right. What was I forgot what I was gonna say, but there's really no specific topic tonight. we could just talk about whatever y'all want to talk about. I'll be here until probably about 8:30, maybe 9 o'clock Central Standard Time. Let's see. Blah, blah, blah. A defendant must also have sufficient minimum context with Missouri to satisfy due process requirement. This is some sort of territorial type thing right here, man. Whenever I find this stuff, I'm gonna start studying this stuff more often. And whenever I find this stuff out, I'm gonna be posting cases on it. I'm gonna start going live and telling y'all about it. So, the nature and quality of the contact, the quantity of those contacts, the relationship. So let me see. It says five factors are considered by the Missouri courts. They're talking about the minimum contact type thing right here. It says five factors are considered. Let me go and read this. Let me see if I can pull up these factors right quick. This is from 1990. So this stuff been going on, man. They've been new about this stuff. How your case going, JR? How are your cases going? To deny appellate Missouri, where imprison can be established. How your case going, JR? Let me see. Five is present 4 points. The affidavit, where is it at? Personal jurisdiction. Trying to pull it up right now, y'all. Sorry about that, y'all. They won't respond to nothing. Boy. Normally they normally do that when you write about something. JR says waiting on the judge and file the motion for discovery. They normally do that when you write about something. Like when you wrong, they are not gonna hesitate to tell you that you're wrong. They ain't gonna do that at all. So when just take that as meaning that you may be on to something. They're not gonna tell you when you're right. Not if you're a pro se litigant. It's like I had a guy on the phone tell me he tried a case by himself, and when he presented his arguments in court, the judge, so-called judge or whatever, looked at opposing counsel. I think it was like one or two attorneys in there that he was going against, and she looked at them and she said, "I'm sorry, he's right. I can't ignore this. I'm sorry." She apologized to them because he was right and they were wrong. That's crazy, man. Why are you apologizing to them? This goes to show you, man, these people are trying to preserve the status quo, and they're trying to protect their jobs, their pecuniary interests in their careers. Those are the only two reasonable explanations or reasonable conclusions that I can come up with for these people who act like this. You can be 100% right in your argument. I mean 100% right, man. And they will deny it, one page, one sentence, and they won't tell you why. You might not even get a sentence. It might just say denied, and they won't tell you why. And then when you try to go and appeal it, the appellate court probably just it depends on what the issue is that you're bringing up on appeal. Like I did one day, I was bringing up the right to travel. Don't do that in no court, y'all. Do not do that. That's just my personal opinion. Let me say that I'm about 99% sure that you should not do that. I'm not saying you're wrong. I'm saying it's too controversial and too political, for them to rule on. So they're not gonna rule on it. That's just my take on it. They do whatever they want to do, y'all. I'm sick of it. Anyway, let me get back to these five factors. It says that the defendant must also have sufficient minimum contacts with Missouri to satisfy due process requirements. 5 factors are considered by the Missouri courts: the nature and quality of the contact, the quantity of those contacts, the relationship of those contacts with the cause of action, Missouri's interest in providing a forum for her residents. Notice they talk Missouri's interest. Missouri is not sovereign. Missouri's interest in providing a forum for her residents, and the convenience or inconvenience to the parties. The first 3 of these factors are considered to be of primary importance. The last 2 of secondary importance. This is crazy, y'all. This is crazy. Crazy, crazy, crazy. Y'all hit that like button for me if y'all haven't already. Hit that like button for me. I'm trying to think of who was that. I think that was Romeo or Jeff or somebody like that. He was saying that he's from Ohio and he was traveling through Missouri. And I'm guessing he must have got stopped or something. That's why I'm reading these Missouri cases. Hopefully he'll be watching this video. But it's this minimum context thing. If that so-called judge had jurisdiction, she wouldn't hesitate. She wouldn't hesitate at all. He don't have to. You don't have to grant the court in personam jurisdiction over your person to rule on a motion to dismiss. You don't have to do that. So she playing with you, man. She playing these games with you. That's what she doing. She don't want you to know this, but she playing games with you. Let's see. I'll give y'all a few updates. I'm still a little the ebook for the DC circuit is still paused. I can't really finish it, y'all. I just can't finish it. Because I'm working on cases. I'm working on I want to say two almost 3 federal cases. And a state, well, 2 state cases and 3 federal cases. So I really just, I honestly, I don't have the time. That's why I was telling y'all, that's why I was trying to get 2 to maybe, I say about 200 people to donate $15 to $20 so I can just focus on the book, so I won't have to do anything else. I can just focus on the book, to get the book done for y'all. But I started taking cases for people. So that's really the issue right now. That's the holdup. I don't know when it's gonna be done, but it will be done. It's gonna get done. All right, all right. So let's see. Analytics, streaming settings, stream health, excellent stream as hell. Okay. So the quality of the video is good, the volume is good, all good. Okay, so what's your next move, JR? You have a next move that you're waiting on? They won't respond to anything, boy. They be working together, man. I'm trying to tell you, man. They work together. I wouldn't be surprised if they have each other's cell phone numbers and email addresses, and none of that stuff wouldn't surprise me, man. I wouldn't be surprised by none of it. They just be working together. Let me see if I can start posting some comments on there. I want to start doing equity too, y'all. I want to get back on the equity too. What must consider the burden of the defendant, interest in the form stating the plaintiff's interest in obtaining relief. Okay. I'm gonna cite this minimum context case. Let me go to the group right now, and I'm gonna cite this in there. You filed discovery. Hold on. I'm gonna get back to you in a second, man. Hold on. I'll delete that later. Make sure. All right. Let's get to this. This is gonna be. I'm about to post the minimum context. Right now. For what's his name? I forgot his name. But anyway, this is where they get that minimum context thing from right here. This case, the case that I just posted in the chat, that's where they get that minimum context. Filed on 1031. Okay. So let me see. What does the rule or the statute say um in regards to how long they have to answer your discovery, JR? Because it's normally in the rules of the statute. Amended the complaint on 9/11. Okay. Wait a minute. You in federal court, right, JR? This is in federal court, right? Is this a 42 section 1983 lawsuit? How you doing, Miss G? Um, okay, you say you messed up, need advice. Okay, go ahead. I'll see what I can do. Go ahead. Amended the complaint on 9/11. That on 1031. 1031. I think they got. I want to say they got 30 days to if this is in the if this is in federal court and you're doing it under the federal rules of civil procedure, I think you got 30 days. I think they got 30 days to answer your discovery. Motion for discovery. Hold on. No. Oh, okay. Look, are you in federal court, JR? Because I didn't file a motion for discovery in my case. I got my discovery though, but I didn't file it. And hold on. Okay. So did y'all? Okay. All right. Okay. Okay. Look, you filed your complaint. I'm assuming since you had the amended, they may have moved for a motion to dismiss or something like that. I don't really know. So you may have filed a motion for leave of court to amend the complaint. Did the judge grant your motion for leave of court to amend the complaint? I'm assuming he did. If you did it on 9/11, okay. So if you did that on 9/11, they had to answer your complaint. They had to re-answer your complaint again, 21 days after you served them the amended complaint. Let's see what's next. How did it work out in my case? Okay, so did they answer your amended complaint? Okay, the officers answered. Okay, so they answered your amended complaint. Um, you shouldn't file a motion for discovery. Did you have a I think is it a rule 26? They call it a conference where you're going to meet with their attorney, and then y'all discuss how the case is going to proceed, such as how many sets of requests for admissions, how many sets of requests for productions, how many sets of interrogatories you get, how long the trial is going to last, um, um, when is the end of discovery, like how long is discovery going to last, how do you want to get service of process throughout the duration of the lawsuit. When a motion for summary judgment has to be filed, yes, waiting on the conference. Okay. Well, don't you might want to withdraw your motion for discovery, because that's you have okay. When is the conference? When is the conference? Because at the conference, the reason what I'm trying to get you to understand, JR, is at that conference, you can talk to the attorney about when that y'all want to proceed, with start to serving discovery. is what I'm trying to say. I'm stumbling over my words, but that's essentially what it is at the conference. Cause at my conference, me and defense counsel, their which is their attorney, we agreed that at the end of the conference that day, then we were going to go ahead and start with discovery. So he had already had his discovery ready. So back to when you said waiting on response from the judge for file a motion for discovery, I gave you the wrong advice because I thought this was in state court and I thought this was a criminal case. This is a civil case, so I gave you the wrong information. So if this is a civil case, don't even worry about the motion to for discovery. It's gonna be you and the counsel, whoever the attorney is, y'all will discuss when y'all want to start discovery, when it's gonna end, how much discovery is needed, how long is the trial is gonna be, so on and so forth, like that. When is your conference, Jr.? Well, I love my chair, y'all. I paid about $200 for it, but I love this chair. Very comfortable. Said it's too much to type. I don't have a call-in number tonight, Miss G. I'm sorry. The call-in number will be if I can come on tomorrow. Uh, if I come on tomorrow, I come on a little early tomorrow since tomorrow is Sunday, so I probably come on probably about probably about 4 o'clock tomorrow, and we'll do probably about 2 hours tomorrow or something like that. No conference day set. So you got the answer from them. So what's the hold up then? Okay, after you got the answer from them, um, what were the orders of the magistrate judge then after you got the answers from them? Now they may be like if you just got the answers from them, let me see. Too much to put here. It's been a while. Okay, Miss G. I'm sorry. I'll try to get a call in number. Well, I got a call in number for tomorrow. So we'll just have to do it tomorrow. If, JR, when did you get the answer? Because the judge may be waiting to see if you're going to file a motion to strike any of the to strike their answer. Nothing as of yet. Okay. He may be waiting to see if you're going to file a motion to strike their answer because you can move to strike their answer because an answer to a complaint is also a pleading. Okay, they filed the answer on 6/29. Well, it's way past that then. So no, you can't move to strike it now. You got like what 21 days or something like that. So you've been waiting since June 29th and no orders have been entered into the court. Is that what you're saying? Because that's crazy. That's like 5 months. What they got going on down there? Motion to strike 571. Okay. So did they grant the motion in its entirety or partially grant the motion? They probably got pissed off when you filed that motion to strike. The attorney, when I filed my motion to strike, the attorney he threatened to he what is he threatened to file a rule of he threatened to file a motion to sanction me for filing my motion to strike. If I didn't withdraw my motion, he was going to move to have me sanctioned. And I was like, well, go ahead and do what you're going to do because I ain't withdrawing my motion. He was just bluffing, though. He was trying to scare me. He said my motion to strike was meritless. That's what he told me. The judge has been silent. That is crazy. That's crazy, man. Okay, here's what you do. Do it under Rule 7, Jr. because any type of motion that you want to bring before the court, if it's not in the rules of the federal rules of civil procedure, then you got to bring it under Rule 7. I think it's Rule 7. So what you can do is you can say comes now pursuant to Rule 7 of Federal Rules of Civil Procedure to move this court to issue an order for a Rule 26B scheduling conference or something like that. Do that. Try that and see if that works, because that's ridiculous. That really don't make no sense to me. That's ridiculous. If you haven't hit that like button yet, hit that like button. Man, I be sitting down, y'all. I sit down in my chair like I sit down in my car. This is how I sit down in my car. Like when I'm traveling in my car, I be just like this. Or I just do this. I do it with the right arm. I be just like that, chilling. That's how I move, just like that. Try that what I just said out, Jr. Matter of fact, let me look. I'm gonna look that rule up for you right now, Jr. Give me a second. I'm gonna read the rule to you so you can understand it too. Let's go to Federal Rules of Civil Procedure. Boom, right here. So give me a second, Jr. I think I use that rule too, Jr. Just to let you know. That's why I was telling you to do it. Um, Things allowed. Let me see. Here it is, right here. Okay, Jr. It's rule. I'm gonna type the rule in right now. It's gonna be Rule 7B. Okay, and I'm gonna copy and paste what it says. Rule 7B, motions and other papers. 7B1. When you go and read Rule 7B1, it's gonna tell you what I'm talking about. Let me see if I can put all this up. I might not be able to put all that in there. That's 50 something. Yeah, that's too much. Okay. I'm gonna delete some of it. Okay, that's cool. All right, I'm posting the. Give me about 10 seconds, Jr. And I'm gonna post it for you. Um, the motion must. Then it's going. When it says the motion. Hold on. There we go. Right here. All right, Jr. Read that rule right there. That's the rule right there. You want to bring that motion under right there. So I'm gonna read the rule out loud while we live. Okay, Rule 7B1 of the Federal Rules of Civil Procedure. A request for a court order must be made by motion. So whenever you want the court to do something, you need to bring it by motion. You need to bring it by and when you use that this is the I'm sorry, I can't even get the word that I keep trying to talk so fast. I'm sorry, y'all. But anyway, the rule that you want to use is Rule 7B1. A request for a court order must be made by motion. The motion must A. be in writing unless made during a hearing or trial. B. State with particularity the grounds for seeking the order. And C. State the relief sought. Okay. Now I got to find out what conference what rule is that conference under. I want to say it's 26. I want to say it's 26. Y'all hit that like button for me. Hit that like button. What was that? De La Rosa. What's good, man? What's good? What's good? I think it's 26. I'm trying to find this rule, man. Hold on, y'all. What is that? Let me see. What is that rule? I gotta find that rule. It's in my I gotta go look through my case files because it's in here somewhere. But that's what you want to do since the judge is just taking his time, just doing what he want to do. I'm good, man. I'm good. Let me see. Scheduling. Summon strategies for what is this? Shotgun pleading answer defenders. This ain't it. I gotta look through these documents for you, Jr. I'm trying to find it for you, man. What is this? It's not a rule 26. I gotta find it. I forgot which rule it is. It might be it's 20 something. I don't know which rule it is, but it's 20 something. Here it is, right here. They call it a preliminary scheduling order. That's what it is, and it's under in preparation for entry of a federal rule, civil procedure 16B, rule 16B. Yeah, I got you, Rosa. I got you, man. De la Rosa. I got you. So let me go and read. It's rule 16B. Here it is, right here. Purpose of a pretrial conference. In any action, the court may order the attorneys and any unrepresented parties to appear for one or more pretrial conferences for such purposes as one, expediting disposition of the action. That means disposing of the case. Establishing early and continuing control so that the case will not be protracted because lack of management. 3. Discouraging wasteful pretrial activities. 4. Improving the quality of the trial through more thorough preparation. And 5. Facilitating settlement. B. Scheduling order. Except in categories for actions exempted by a local rule, the district judge or a magistrate judge, when authorized by local rule, must issue a scheduling order. Check your phone. I sent you what has been filed. Okay, I'm checking right now, JR. Motion. Judicial notice, proposed amended complaint. Let me see if I can see it. I'm gonna have to go and look it up, man. Because it's not gonna let me see it. I have to hold on. What was that? Yeah, it's not gonna let me see it. Hold on. I think well you probably can motion for discovery. I've never done it. That's why I'm saying, like, in my case, after the pleading stage was closed, we went. I mean, the judge issued an order pursuant to the Rule 16, a pretrial scheduling conference or something like that. That's what the judge did. The judge did that sui sponte, which means on his own. I didn't motion for it or anything like that. They just did it because that's what they wanted to do. Um, let me. I have a Pacer account, Jr. So let me. I'm gonna go and look at it because I got a Pacer account. So give me a second. I'm gonna leave the federal rules of civil procedure up just in case I need to go back to it. Pacer. No, that's Illinois. We gotta go to Google. I gotta find it right quick, man. Yes. Oh, I just got another message. What is this? Oh, he must have. What is up? I don't know what this is. Anyway, all right, give me a second, man. I'm on Google right now. I'm about to go and look it up right now. I got your case number, so I should be able to find it. Wait a minute, you in? What did you file this case at? I forgot where you filed it at. I think it was in Wisconsin. So that means Wisconsin Eastern District Court. Okay, so I got to go to the U.S. District Court for Wisconsin. Uh, Wisconsin Eastern District. Okay. Um, blah blah blah. I got you, man. Give me a second. Y'all hit that like button for me if you ain't hit it. Hit it. Stop being stingy, y'all. Don't be stingy now with that like button. Where we at? Is this it? Let me see. Search for it. Dang it. Here we go, right here. We in Wisconsin. I'm sorry, y'all. It's gonna give me a minute. Give me a minute. Wisconsin. Wait a minute. TVW. What? I don't even see it. I don't know what they got going on here. I don't even see Wisconsin on here. I know my ABCs. I ain't skip over it, did I? New Mexico, Ohio, Pennsylvania. Oh, okay. You got to go down. There we go. Okay. Wisconsin. There we go. Eastern District right here. So you in the Seventh Circuit. All right. Robert Hodges. I tried the Sunshine Act to the court and to a few agencies. Cricketed. I did file a case a while back, Hale versus Hanker, to get the jury to get discovery. What do you mean, Robert? What do you mean? Oh, all right. I got you, JR. I got you. I do my best. I do my best. I tend to just read what I say. Pacer, case locator, Pacer. What is what? Why I have to go through all of this just to like? Pacer just get on my nerves sometimes. Boy, they get on my damn nerves. Okay. Find cases. Case number. All right, I'm looking up I got the case number right now. 2, 3, 2. Let's go search. It's loading up right now. It's in the Eastern District. Yeah, I'm in. Well, I looked it up in Wisconsin. It says Wisconsin Eastern District. The prosecutor I heard goes to a school to learn to lie to a jury and mislead. I did not know this. You talking about to get an indictment, Robert? Is that what you're talking about? It's man, this okay. It's going pretty slow. Man, there are so many cases on here with this case number. This is ridiculous. I gotta go back. It's hold on. I think I found it. Let me go and see. I think I found it. I had to open up so many windows just to find it. This is ridiculous. Okay, docket report. We're gonna get a docket report. Hopefully this is it. Yeah, I think I got it. I think I got it. Um, is the last letters in your case, JR, do they begin with a L and a A? That's the those are the judge initials. Is that what you're talking about? I mean, is it a L and A, an indictment and a and during trial? Okay, let's talk. I can give you some insight on the judicial system. Man, I don't have a number tonight, Mr. Martin. Rick, I scheduled the live for tomorrow. I thought I did it for today. Look at a case before 1863. What's the name of the case? Okay, you filed for discovery. Okay, I see your motion for discovery. Let's see. Here in Seattle, I was told a special school, the prosecutors are dirty one before private practice. He had was misusing funds by clients and DV cases against him. I don't know, none of that stuff surprised me. I ain't surprised by none of that stuff. None. It just don't surprise me. 13 pages. Man, look at you, JR. Look at you. But you calling me for help. Man, I told you don't need no help, man. You know what you're doing. You probably just needed me to confirm that. Cause I do the same thing. So don't feel bad. I sometimes to this day I second guess myself. All cases before 1863 have merit. Okay. There's a few good PDFs on indictment and wrongful arrest treaties on false arrest. See what's going on. I'm gonna look at the text right now. What's going on, Robert, is it's the nature of the action. Yeah, I got it. I got it. That it's the nature of the action. See, they're modifying um the common law through statutes. That's what they doing, man. Because in a particular jurisdiction, you really don't have a right. If I'm not mistaken, you don't have a right to a trial. The nature of the action, it's not common law jurisdiction. It is not common law. Um, May 20th, 13 pages. The complaint reads, use contractors to ensure the successful operation of child support. According to Rule 26B1. Rule 20. Okay, Rule 26B1, is that pursuant to the Federal Rules of Civil Procedure, JR? Not to brag, I have to put some judges in prison than anyone I know of. Oh, you said I have put more judges in prison than anyone I know. You need to be bragging about it. That's something to brag about if you ask me. Cause that man, look here, whew, they don't like to go against their own man. They don't like that. They do not like that. That's something to brag about if you ask me. So you need to be bragging. That's what you need to be doing. Cause they don't play by their own rules, man. The defense of me on the Rockefeller doctrine is not applicable to private organizations. Rule 26B1. What? Rule 26B1. Motion for discovery. Let me go and see. This must be for initial disclosures or something like that, JR. That's probably what you're looking for, initial disclosures. If it's for initial disclosures, you don't even have to motion for that. They got to give you that, if I'm not mistaken. I think you're talking about initial disclosures. Yeah, that's what you're talking about. You said B1 though. What's B1? Let me see what B1 is. B1 proceedings is information disclosed. 16 judges, 22 prosecutors. You got them sent to jail? That's amazing if you did that. B1. The innocent individual who is harmed by an abuse of governmental authority is assumed that he will be compensated for his injury. I agree. Officers of the court have no immunity when violating a constitutional right from liability, for they are deemed to know the law. I agree with all that. This is what I was telling y'all about, man. They don't. I'm when there are actual good, unbiased so-called judges, I do believe that they should be entitled to immunity when they deserve it. When they deserve it. Not just you don't have carte blanche to do whatever you want to do and still get immunity. No, you can't do that because what's going to happen is people are going to start getting upset and all hell could potentially break loose when you do stuff like that. Because how is it fair for me to follow all the rules or whatever, but the rules don't apply to you? But you want me to follow these same rules that you just think that don't apply to you. It don't make sense to me. Trump took me off the terrorist watch list in 2016. Judge has been silent. Well, if you did that, Rick, thank you. Thank you for doing that because these people think that they can just do what they want to do, y'all. These people really think that they sovereign and they can do whatever the hell they want to do, whenever they want. That's what they think. Um, motion for discovery. Now, I'm gonna say this, Jr. I almost said the name. I'm sorry. I'm gonna say this, Jr. Um, there's a lot of stuff in this motion for discovery. It's irrelevant. It's irrelevant. You shouldn't even be arguing any of this stuff in discovery. This is something like this should, in my opinion, this is just my opinion. This should be something that should be in like a memorandum of law or something like that in support of like a motion to dismiss, a motion for summary judgment, or in some cases, yeah, you can put this in a motion, for discovery. But I just think it's pointless at this point. I think you should use that rule 7 that I cited above, and to ask the court for an order pursuant to rule 16B, I think, of the Federal Rules of Civil Procedure, because you want this judge to go ahead and issue an order so they can go ahead and schedule a pretrial. I think it's a pretrial conference or something like that, so y'all can go ahead and get this thing going. That's what you want. Watch out for silence because when they come back, you won't believe what they come with. You right. She showed right, Miss G. You showed right. You are absolutely right. Absolutely right. That's why when they dismiss your case, let me do this again. When they dismiss your case with or null prosecute your case and they say it's dismissed, don't believe that. Because that's a dismissal without prejudice, which means they can bring it back under a different set of facts, as long as, if I'm not mistaken, as long as it happened on that same day, then they can bring it back. So when they do that, what you need to do is, um, if you can pursue it to some statute, some expungement statute, you need to go ahead and proceed with your administrative procedure in the proper so-called court to petition to get it expunged, so they can't do it no more, so they can't bring the so-called charges back, because they will do that. They will do it. If you ain't hit that like button yet, you better hit it. Stop being stingy with that like. Don't be stingy. Ah, ooh, boy. Let's see. 16 judges and 22 prosecutors. Man, that's impressive. You know something I don't know because I haven't been able to get one judge. I haven't tried yet, but I don't like they so corrupt. It's just pitiful, man. Pitiful. We now spend 1 trillion a year for interest to other countries. IRS collects 3 trillion a year. Great Depression, Grandma said to people work, police, and dog catcher. Oh, you said the Great Depression, Grandma said two people worked, police and dog catcher. That's funny. That's funny. That is funny. Oh boy. How was the quality of the video, y'all? Is it showing up pretty good? I went and got my laptop today. I had the money. I was just like, forget it. Let me just go and get it. Um, so can y'all tell me how was the quality of the video for everybody? On a scale of 1 to 10, how good is the quality? Just put your numbers down in the chat if you don't mind. Uh, okay. Let me get back to this. That's what I think you need to do, Jr. I think you need to do that. Wickerfield is not a jurisdictional giant. I was wondering if you got it. If I got what? You say you was wondering if I got. Let me go and see. I might have missed some of y'all comments. So let me stroll back up. I'm sorry. I can tell the difference. Oh, okay. You talking about the laptop? Yeah, yeah, yeah. I went and got it. The quality is that good? That's good. It needs to be good because that camera costs about $800. 1 second. Be right back, y'all. I gotta get another bottle of water, y'all. Give me 1 second. Thank you. Thank you. Thank you. Thank you. Sorry about that, y'all. Okay, probably a 6. The computer. Okay. Some saying 10, some saying 6, some saying 7. So I probably got to work on the settings because I didn't even set it. I don't even know how to set it. I think it automatically set it or something like that. But I don't really know. I wish to speak, but you that make you voice heard. Let's see, Rick, did you ever get your if this is the same Rick? Um, it's definitely better. I appreciate it, man. Appreciate it. I'm glad the quality is better, but I gotta play with it a little bit more to see because I really I don't know what I'm doing, y'all. Um, get your card out. Put some vodka in your water with a squeeze of lime. I don't know if I can handle that, man, because I don't drink. I don't smoke or drink, so I don't even know if I can handle that. All right. Let's see. Qualified immunity protects government officials from civil damages so far as their conduct is not violent, clean, blah blah blah. Yeah, I think Jr. I think you need to do what I suggested to see if that works. I don't really want to. I mean, I don't really want to tell you how to litigate your case. Um, but just try to stay away from topics that are too controversial because they will they'll just kick it out or they'll delay and won't do stuff like how they doing right now. They'll do stuff like that because it's so controversial and they don't want this stuff on the public record for people to see. That's just my opinion. But that's what I think it is. Um, I have the light off too, by the way. I only have the light on. So, um, anybody else got something they want to look at? I don't know how long I've been live. How long? Let me see how long I've been live. I'm gonna stay about an hour and 30 minutes. I don't know how long I've been live. But you're doing good though, man. It's okay to make mistakes. You feel me? It's okay. That's cool. I make mistakes. We all do. So don't take it the wrong way, Jr. Um, I'm trying to. How long have I been? I don't even know how long I've been live, y'all. Like I'm. It don't even say how long I've been live. Let me go and check. I think I gotta go. BS. It should tell me. Um. Okay, so I've been live about an hour and 7 minutes. Okay. Yeah, hour and 7 minutes. All right, so I'm gonna leave in about 20 or 30 minutes, y'all. We'll have to talk. We can try tomorrow. Rick, we can try tomorrow to talk tomorrow because I scheduled the on Blog Talk Radio for tomorrow. I thought I did it for today, but I have a call in number tomorrow, so we can try it tomorrow. Okay. Um, any particular topics that y'all want to discuss? Or are we just freestyling right now? What's the motion to this? Plaintiff's motion for discovery. Okay, it says the audio stream's current bit rate. Slower, we'll check that out later. What time tomorrow? I say about 4 o'clock Central Standard Time tomorrow. And I'll go from 4 to 6 tomorrow. We'll do 2 hours tomorrow. 2 hours tomorrow. 2 hours. You and I need to go live. Oh, you want to do like some like I don't know. I don't really know how to do that. I mean I can figure it out, but like when it comes to this, like I'm novel. I'm new when it comes to this tech stuff. Like I ain't not no tech genius or nothing like that. So I don't know. We can try something out. If we can't do the video live, what we can do is you can call in tomorrow and press 1, and you'll be live on the air, and people on the channel they'll be able to hear you and stuff like that, and we can engage into conversations like that. Y'all, I remember, I remember, I was in court. This was district court. Okay, well, yeah, let's do it tomorrow, man. 4 o'clock Central Standard Time. What time zone are you in? Is that a good time for you? I was in court. This was district court. I was still new. I had been studying. I knew a little something, and I didn't, know too much. But so I'm in court. This was a traffic ticket case, and this was a so-called district judge, and they had a trial or whatever. We had the trial, and so the judge then looks at me. He says, "Well, sir, at this point in particular time of the trial, you can go ahead and cross-examine the defendant if you have any questions and things like that. Now, do you have anything to say?" I said, "Yes, sir, I have something to say." There's a courtroom full of people in here, y'all. So, but he didn't know me at the time, and he didn't knew that I know. I knew a little something. So I was like, "Yeah, I got something to say." And I learned all of this stuff. Y'all might know this guy. I learned most of that stuff, what I'm about to say now, from a guy, Carl Miller. Carl Miller. I think he was out of Michigan. I heard he passed away. So my condolences and rest in peace to Carl Miller. But that's where I got what I'm about to say from. So I said, "Yeah, I got something to say. I'm here on a special appearance, and so adequately distinguished in legalese from a general appearance, and all questions shall be answered in the form of a demur." Now, when I said that, the judge went from this to he just did that. Like he was shocked. He was so shocked. And then I guess he must have caught himself, and he said, "Do you have anything else to say?" I said, "Yeah. I motion to dismiss for failure to state a cause of action which relief can be granted." He said, "I deny your motion." Before I can get on what grounds out of my mouth, this man said, "I don't have to tell you why I denied your motion." And then eventually he ran out of the court. I'm telling y'all, he ran out of the courtroom. He ran out of the courtroom. And they sent in a state trooper. They sent a state trooper in there to scare me. Said, "Man, you about to be held in contempt of court." I said, "Contempt of court for what?" He said, "Man, you can't be in here showing off the judge like that." I said, "Wow." I said, "Wow. Wow." Rick, okay. So you knew Mr. Miller, Carl Miller. That's good, Rick. Let me see. Lloyd Holland Miller, Jr. Good case archive, a free read. How the government breaks the law. Prosecutor lied. Man almost died 4 times on death row over police. And prosecutor lied. An excellent book. Oh, it's a book. Okay. They if they know me, Rick, they very careful what they do around me now because they know, like, I don't need paperwork. I mean, it's best to have all of your paperwork and file it in there, but I don't need that stuff. All of this stuff, if they want to ask me questions and start testing me, they can. But I kind of wouldn't do this in a municipal court, because municipal courts it's not a so-called court of record. Now, if you go to a district court or a circuit court, they have a court reporter in there, and they're free. The court reporters are free. I think you need to hop on a little and drop some jams. Hop on the line and drop some jams. We'll do it again tomorrow, man. 4 o'clock tomorrow. I'm currently in Michigan from Texas. So I noticed you said Carl Miller was a very good friend. You used the term "was" as in past tense, if I'm not mistaken. So is it true that he pass away, Rick? Did he pass away? If so, when did he pass away? All right, I got 11 viewers. I need 11 likes. Stop being stingy with that like button, boy. Y'all stingy. Ooh, y'all stingy. Let's see. But yeah, man, he was shocked, man. That judge was shocked. His name is Bob Shirley. He was a district judge. He didn't know me. He didn't know me. Bob Shirley. I think he's still a judge down there, if I'm not mistaken. But It was funny. That was very funny to me. He ran out of the courtroom. He came back in, but he ran out the courtroom. He ran out the courtroom. Um, because he had a courtroom full of people in there, and he didn't knew that I knew this stuff. And like I used to walk around my house, y'all. I'm not gonna lie. I used to walk around my house talking to myself, practicing my arguments, like I was crazy, like I was crazy. But that's what you got to do. This was a traffic ticket. You know how much that traffic ticket cost, y'all? $47. Y'all know I ain't paid that traffic ticket to this day. They never issued a warrant. I ain't paid the traffic ticket yet, man. Let's see. That's how you do it. Yes, he has been gone for some time. He was part of a constitutional law group in 1996. And well, my sincere condolences to Carl Miller. I saw his videos on YouTube. I think they were calling it what do they call it? Kick ass Constitution man or something like that. And I got his videos from a good friend of mine. His name is Jose. He's a Mexicano. Um, he's an older guy though, but he put me on his videos. And he was trying to tell me how to argue my cases, but I was so new at this at the time. I didn't know, like, this is a whole new language for me. Legalese. I don't know what these folks talking about, but I didn't give up. He said you won 3 cases so far. That's what's up, man. You gotta stay on. You gotta stay on them, man. You gotta stay on. This stuff ain't hard. I promise y'all, it's not hard. It is not hard. What makes it hard is to tolerate them um when they start violating your rights, and you know they can't do this, and they just doing it, and they just keep doing it. Like ain't nothing you can do about it. Like, they just so disrespectful with it, and there's nothing you can do about it. And you know that they're violating your rights, and you know that they are intentionally violating your rights. I'm talking about the so-called judges. I'm not talking about the police officers, because they really don't. 9 out of 10 of them don't know what they doing anyway. Uh, yeah, yeah, I scared him. I had one judge, when I started asking him questions. No, let me phrase that. He started asking me questions. This was a circuit judge. This was a different judge. And I cut him off so quick. I said, "I'm sorry, sir, but why are you asking me discovery questions?" And he said, "Well, I need to know." I don't know what he said. But he said, "I need to know something." And so I was like, "Okay, well, we can go ahead. I'm sorry, we can go ahead." But I started talking or something, and his whole demeanor changed. He says, "I'm not gonna be intimidated by you." And I was shocked when he said that, because I wasn't trying to intimidate him. I was just trying to argue my case. But he was scared. He was scared, man. What was it? It was another matter of fact, it was the same judge, not Sherling. It was, what is this judge's name? Ben Brooks. He's a circuit judge. He's still a circuit judge, come to think of it. He was I made an argument for him. I was in Alabama at that time, and it was a traffic ticket or something like that. And I got this argument from Carl Miller, and I said, the body corporate state of Alabama arbitrarily and erroneously converted my right into a privilege. Now, since they've done that, and Murdoch versus Pennsylvania clearly states to the contrary, that no state may convert a secured liberty into a privilege, license it, and attach a fee to it. And if they do, Shuttlesworth versus Birmingham says I can ignore it by engaging in that right with impunity. So, Your Honor, the prosecutor is precluded. He is hindered. He is barred from performing his most ultimate task. So I move to dismiss this case and blah 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 blah. So there's an attorney sitting right by me when I make this argument. The attorney stands up and said, "Man, that's a great argument." And the judge told him to shut up. It was so funny, y'all. It was so funny. But I got that argument from Carl Miller. That is a great argument, by the way. That's a great argument. Uh, let's see. I'm 1-3. Oh yeah, we gonna you about to win 4 of them, Rosa. It's about to be 4. Cause we finna get them. We get in our own most of the time. Yeah, we do get in our own way sometimes. Have you sued for a traffic ticket yet? No, I haven't. Uh-uh. John Quaid is another good listen. I think I know who you're talking about. That name sounds real familiar. John Quad or Quaid. Wasn't he like a actor or something like that? A little heavy, a kind of heavy set white guy. I think he was a heavy set white guy. Like when it, dang it, that was a good. I don't know. I just closed the case that I was reading. It was a good case too. Wish I could open that bar back up, but it's too late now. But anyway, I done lost my train of thought, y'all. Oh, I know what I was gonna say. Um, these I lost my train of thought again, y'all. It's gone. I'm sorry, it's gone. It's gone, y'all. I'm sorry. Hopefully I get it back. Have you sued for a It was something in relating to that traffic. Have I sued for a traffic ticket? Okay, I know what I was gonna say. JR, it's just some stuff that I'm just not gonna sue over. Not because I'm wrong. It's because it's just too controversial, and I know that they not gonna act right. Give me 1 second, y'all. All right, sorry about that, y'all. I had to step away for a minute. Sorry about that. No, I had to step away. I'm sorry. I had to step away for a minute. Those 3 were in criminal courts. This is my first time turning the tables on them. Yeah, now you're a prosecutor now. It's a civil case, so you're a prosecutor now. So just like how they just trump up all them so-called charges on you, you trump up on them as many as you can. I don't care if they all meritless. Just you make them spend a whole bunch of money like they do you, because that's what they do. They man, look, man. When they know that you know what you're doing, do not let them do that. Do not let them know that you know what you're doing, because they will hit you with a laundry list of meritless charges, man. It's like they just picking up a handful of mud, throwing it at a wall, and they just trying to get whatever stuck. That's gonna stick. Rick Morton. I'm just hoping we have a good conversation, Rick, because I like having these types of conversations. Um, I gotta get the guy uh in regards to the child support thing. I gotta get him back on the show. Now that I have my now I got another laptop now, a stronger laptop now that can withstand um, the camera. We'll just do it like that. I'm just gonna start. I'm gonna start live streaming from my camera. I gotta fix the specs and stuff on it because I don't really know the quality of it. But what PDFs are you? Ugh. What PDFs are you stating on indictments and wrongful arrests? I need to get that too. I think that'll be real good to look at. But I think I'm pretty good on the wrongful arrest. I don't really know. I might be wrong. But but I know when I'm lawfully arrested and when I'm unlawfully arrested. But the indictments, I mean, I think the indictments kind of work. It kind of works just like excuse me, the complaint. So in the indictment, whatever statute that they're saying that you violated, generally speaking, they have to allege the facts constituting the alleged so-called charge that your person is charged with. They can't do it in a conclusory manner. They can't do that in a conclusory manner because when they do that, they violate due process. Okay. How does someone get in contact with you, David Thompson? We got. See if I'm gonna check my messages, y'all, because I might have got some more messages. Okay. All right, I'm gonna leave and I gotta get off in probably about 3 minutes, y'all. I gotta go and go and get off. So, but I'm gonna add the video tonight. I'm gonna add it on the channel tonight, so y'all will be able to rewatch it if that's what y'all want to do. But how can you allege a violation if it is contrary to the Constitution? It's not. I'm gonna say this. Generally speaking. Oh, wait, hold on. What do you mean, Romeo? When you say how can you allege a violation if it's contrary to the Constitution? What do you mean? And I realized that I read you. You said you was from Ohio, but this was in Missouri, so I read you the wrong case. So I have to go back and read to see how they commence criminal charges in Missouri under the state constitution in Missouri. That's what I need to go and do. I read you the one for Ohio, not Michigan. I mean, not Missouri. You walking out of Michigan with $10 million. That's what you walking out with. That's what we want. 10 million. Let me I had a good case up here. I don't know what where's the case text right here. Okay, I'm gonna try to look this up before I get on up off of here. So this is Missouri. I'm gonna look this up for you right quick. And then I'm gonna go. So we got Missouri. Commencement of criminal charge. Constitution. All right, give me a second. Let me see what I can find for Missouri. The term information, as used in the Constitution of 1875, is to be understood in its common law sense, i.e., a criminal charge exhibited by an attorney general or other proper officer. Jojo, I wish I could tell you what's happening here. You know what? Yeah, I do. I'm gonna just call in tomorrow, Miss G, and we'll try to talk about it. Say this: the Constitution does not give us our unalienable rights. It limits government from trespassing on our unalienable. That's exactly what it does. See, what they did was they gave U.S. citizens, and it seems like they gave state citizens civil rights. That's what it seems like they did. They replaced the unalienable rights with civil rights. Why do they delay everything when you pro se? They don't really do it when you pro se. They didn't really delay it in my case, so I can't say that. It's when you start talking about stuff that is extremely controversial, that they don't want on the public record, they're going to delay it. Stuff that they don't want to rule on, if they don't know how to rule on it, they're going to delay it. Generally speaking, that's what they're going to do. A trial court acquires jurisdiction upon the filing of sufficient information or indictment. Okay, now this is an old case, so this might be a little. Let me see. The Sixth Amendment right attaches after indictment information or the commencement of adversary. Um. Okay, I found something for you. Uh. Romeo. It says in Missouri, a criminal prosecution on a felony charge is commenced by an indictment or a complaint. So they must have charged you with a felony. I don't really know. I'm just guessing. Okay, and pursuant to the Missouri Constitution, it says a criminal charge may be brought by indictment or information. On the Missouri Constitution, Article 1, Section 17. A complaint is a pleading by which a criminal action is commenced. Blah, blah, blah. Has prescribed certain limitations for the commencement of criminal prosecutions. They don't really. It's well. You have to understand this, Jr. Criminal cases take take priority over civil cases because you have certain rights in so-called criminal proceedings that are more important as opposed to in a civil case. Despite the fact that congressional records of 1983 reveals that the 14th Amendment was never ratified, let me see. By exercising the Seventh Amendment right, if the indictment is contrary to the Constitution and they charge you because they say it's wrong, malum prohibitum. Okay. I think this is a word game that these people are playing, man. They're saying without them saying it, they're saying that this instrument, this firearm, is a product of commerce, or so to speak, or something like that. I can't really explain it, but it's something like that. The reason why I'm saying it is because all crimes are commercial. This stuff is all commercial. So that's why I'm saying that. I'm surprised the feds didn't pick it up. Who is making a valid claim, complaint of unconstitutional deprivation of rights on the color of law or go of the law? We the people can change things if they come together. Yeah, you're right, Miss G. We sure can. You're absolutely right, but I don't know. People so dumbed down. I don't know what's gonna happen. I don't know what's gonna happen. But y'all, look, I gotta go, y'all. I gotta go. We'll do it again tomorrow, 4 o'clock Central Standard Time, 4 p.m. Central Standard Time. And just call into the show if you want to call in. Call into the show. Hope everybody enjoys their Saturday night. Y'all be safe out there. If you in the hood, y'all know how we say it. Stay dangerous. And we're going to get on up out of here, man. Peace, everybody. Oh, I got a headache.